All right, good morning, everyone. We're a couple of minutes late getting going here, but we will open up the hearing on House Bill 358. And I do not see Representative McGuire here. I know the House has session running concurrently with us, so I'm not sure who we're going to have to introduce the bills. But Simon, you don't see her out in the hall there hustling in, do you? Okay. Would you like to introduce? All right. Thank you, Senator Gendro.
Good morning, Mr. Chair and honorable member of the committee. For the record, I'm Carrie Gendro, Senator Gendro, District 1, and I'm here to introduce House Bill 358. This bill makes various changes to the procedures for the filing and adoption of proposed administrative rules. This bill is a request of the Joint Legislative Committee on Administrative Rules.
Thank you, Senator. So, Carolyn Virtue, would you like to come speak with us? Turn it on, yeah. Hit it again until the red light comes on. There you go.
Good morning to my honorable senator.
Good morning.
I am honored to sit before you as a Senate chair for the first time, and it's an honor to be before you, Senator Gendro, as well. I rise in support of Senate Bill 358 today. I think what is in this bill is a great first step to addressing issues with the administrative rules, statute, and process. I am a provider of case management services. There are many rules that I operate under. I served in the House on ED&A and was involved in rulemaking process for any dinosaurs in the room. That was a long time ago. And I do think that in the last number of years, with the loss of institutional memory of both the staff and the representatives of DELCAR, something has been lost with the following of statute, state and federal statute to promulgate rules, and I would like to offer some examples. The first example I will offer is in regard to BEAS Form 3760. This is a proposed form, and as far as they are proposing it with the initial proposal that hasn't been filed yet of the HEE 805. As far as I can tell, and as far as the department has responded to me, there is no statutory authority for the creation of the form. I'm going to pass this up. I have one copy with me today, and I'll upload it to the website if that's okay. When I ask about the statutory authority for the form or certain parts of HEE 805, the answer is the statutory authority comes from the waiver. I went through this last year before Delcar with the HE 801. Half of that rule as it exists today is in place because it's in the waiver, was accepted as authority. I have a problem with accepting the waiver as authority because there is zero input of this body into the waiver. So the Department of Health and Human Services puts it into the waiver and then uses waiver as authority for the rule. This happened with several HEM rules, HEC rules last year. The waiver is cited as the authority. And where that has not come before this body, I am vehemently opposed to that. The other thing I will add, it's a little bit like a chicken or the egg argument. So as they're doing the waiver, I'm testifying, you have no authority in statute or rule to do this. And they're like, oh, well, that's not what this meeting is about. And then I go to the next meeting before Delcar and I'm like, there's no statutory authority or rule. And they're like, well, it's in the waiver. So I did review the statute in its entirety several times this week, and I do not believe that there exists authority to promulgate a rule with the waiver, but it's happening. So I'm not asking for change. I'm just asking for better enforcement at the Delcar level and of the laws that exist. And certainly this language that's before you will go a long way toward forms being created that have no basis in statutory authority. So the form before you is being created with the waiver cited as authority. Now, since my testimony may sound a little unbelievable, and that we are not promulgating rules on something other than statute, I submit for your review a portion of a transcript of the hearings that have occurred where the department staff, and I've highlighted that, say the waiver is the authority when I pose the question. This is the department's transcript. This is not mine. They sent it to me. I've highlighted it here. In this portion of a transcript of a meeting that was held on Monday of this week, maybe it was last week. This week? Sorry, this week. It's been a rough week. Monday of this week, the department responds to my request for statutory authority by telling me it's in the waiver, and they further went on to say that the 801 last year, which I opposed portions of during the Delcar process, was promulgated through the waiver. So they actually admit that from last year in their testimony, and I will send that in its entirety to you by email to the full committee. Lastly, and I do thank you for your time, I am going to hand to you the initial proposal as it exists right now, and in the definitions on I think it's on page 2. Hold on. in the definitions, they remove the reference to the only statute that exists. And I will get you that. Where it is. Hold on. It's on page 1, so I stand corrected. And when they define case management agency, they remove the one reference to statute for case management. And this is a case management rule. So I think it clearly demonstrates that there's little to no understanding of what we're promulgating these rules on.
Where on line 1 would we find that?
I'm handing it over
We're
now.
on page 1, I'm sorry.
It's an initial proposal that they're working on for the HE 805, and they have removed the singular reference to case management.
Okay, so it's not in the bill here.
No,
Okay, I'm sorry.
I'm testifying to the bill
Yep.
and what the process, from my perspective at GELCAR, and the processing of an administrative rule is right now. I support the bill in its entirety, and I'd ask you to go a little further if you could figure out how.
Thank you. We have questions? I'm sure we will. It just may take us a second.
Take your time.
Senator Perkins Coker?
This is an easy question.
A what question? I'm sorry, I've lost the hearing in one of my ears.
This
And
is
it's,
an easy question. Could you just introduce who you are and who you're testifying on behalf of?
I'm sorry, I thought I did that. Carolyn Virtue. I own and operate a case management company called Granite Case Management. And my examples that I've put forth are current is a current example of what we are working on presently. And if it would be helpful, I could give you last year's example and the year before as well.
Excuse me, Senator Carson.
Thank you, Mr. Chairman. Good morning, Ms. Virtue.
Good morning, Senator Carson.
I'm trying to understand what you're talking about, and I find it a little concerning, especially your statements about having the authority through the waiver. Is there language in here concerning that?
Yes.
Could you put that?
No, in the bill?
Yes.
No. I think
Yeah,
the,
that's where I'm confused.
okay.
I look through the bill and I go, I don't see any language. Are you asking us to include something like that in this bill about prohibiting, perhaps,
Yes.
in some sort of waiver that they don't have the authority that they claim that they have?
I am asking that you make it clearer that rules are promulgated under statutory authority, federal authority. We have rules that are being promulgated on other documents.
So is that disclosed to GELCAR when they have the hearings on proposed rules that they are coming from an authority within a waiver?
I believe last year on the HEE 801, that was disclosed to GELCAR.
So again, I just really want to understand your concern is the fact that they have this authority or they claim they have the authority through the waiver and they really shouldn't have that.
Yes.
Okay, I understand.
Yeah, thank you. Sorry, it's so convoluted, but it's a complicated subject matter, so I apologize for not getting clearer.
Sorry, I didn't have my mic on. There are different types of waivers that are given for a variety of different reasons. Is this happening with all waivers, or is this just specifically for one issue versus all?
So it's happening with all of the 1915C waivers. We have 4. And I am not aware of any other waivers because it would be outside of my scope, right?
Yeah.
So the waivers that I do know of, it's happening.
Okay, thank you.
Thank you.
So are these forms a requirement of, is it basically a requirement that's come down with a grant or something like that that says you need this form in order to make this, to disperse these funds or,
No.
okay.
So that form is being created as the department's plan to implement telehealth, but it puts all of the onus of creation of those forms, sometimes multiple times a year, on private entities such as my own. And I would say the cost for getting that form done, it's very similar to the MEA, which is over $250 an occurrence is the current reimbursement for that. I did ask if the department has any intention of paying for it, and they don't. So that's something that they're just putting on private providers.
I got one more. Do you have suggested language that you would like us to introduce or enter into this bill to perhaps clarify that that isn't an acceptable practice?
Well, that's an excellent question, and I didn't before today, but I love the way Senator Carson simplified it.
Okay. Thank you. Senator Carson.
Thank you, Mr. Chair. Thank you again for taking a question. Do you believe that they have the authority through 541A to adopt forms? And the reason why I'm saying that is usually when there's a program, the department or any department, they'll get rulemaking authority. Sometimes it's pretty blanket. It's like, look, you do what you need to do, and that includes the creation of forms in order to implement the program. So they do have authorization, but the authorization comes from the legislature under 541A. Do you think that what you're talking about here with the authority through waivers, that it's in violation of 541?
I believe it is.
Okay.
I believe it is in violation, especially where they create the waiver and then immediately go to rule and cite it as the authority. That's the history of this. So, for example, on the HEE 801 waiver, there's a public comment period. During that public comment period, I said, you have no authority in statute or rule to do what you're proposing in this waiver. And they say, and then put it in rule.
So just to follow up with that, do you think if they want to adopt a rule through a waiver, that must come in front of the legislature, meaning that they have to request that a bill be filed and the legislature would be the ones authorizing it through a waiver and not the department?
So if the department understood that the waiver was not enabling authority for rule, no. But where they don't, maybe. So as I said, when I started my testimony, I'm happy you're dealing with the form piece here. Mm-hmm. I read the rest of 541A. My interpretation, and I'm not a lawyer, would be what they're doing is already not allowed by statute. So the question of how do you fix it, that's why I'm at, I don't know, because I don't think the statute is bad. So if we could get to a place of follow the law, we might not need to mess with it. Right? How do we get there? I don't know.
Okay, thank you.
Further
Thank you.
Seeing none, Carolyn, thank you for coming in.
Thank you so much. And I will get my head around that. If I think of anything, I will let you know. And I appreciate your time today and all day. So thank you.
So I have Emily Johnson, also from Granite Case Management, in favor but not speaking. Is there anyone else that would like to speak to House Bill 358? Seeing none, I'm going to close the hearing. All right, we're going to open the hearing on House Bill 564, and I'm going to recognize Senator Gendro to introduce the bill.
Good morning, Chair and honorable members of the committee. My name is Carrie Gendro, Senator from District 1, and I'm here to introduce House Bill 564. This bill ratifies amendments to the State Building Code approved by the State Building Code Review Board. Number 2, ratifies amendments to the State Fire Code approved by the Fire Marshal and State Board of Fire Control. And 3, adds a fire protection engineer to the State Board of Fire Control.
Thank you, Senator. Sean Toomey, State Fire Marshal, we'll bring you up first. Good morning. Welcome to EDNA.
Good morning. Sean Toomey, State Fire Marshal. Thank you for the opportunity to speak quickly this morning. Obviously, I support the bill. I'll let Phil Shorman, the chair of the Building Code Review Board, speak to the building code amendments, but I do support that process as well. Just in summary, the two amendments that we're asking for ratification on the fire code side today are relative. One is relative generator fuel line. So what we found was that a fuel line from the tank to a generator, there wasn't allowed to have a valve in there, and the valve is critical for DES tightness testing of the fuel line to make sure it doesn't leak. And so what we learned is that for oil burners, you could have an oil tank to an oil burner with a valve in there, and they just pull the valve off. So we mirrored that language since it's like fuels and very similar burning appliance. So we are aligning that language, and that's one of the amendments. The second amendment has to do with food trucks and food trailers. When we adopted the 2018 edition of the fire code, there was some language in there about requiring a gas certification annually by a gas technician for food trucks and food trailers. When it went through the whole process and hearings and such, we all thought it was a great idea. But then when it came to practice, we kind of scratched our head and figured, like, how do we actually do this? Gas technicians had concerns about what it meant, how they do it, what codes they follow, what standards they follow, and things like that. We look forward to the 21 edition of the code, and what it did is it removed the requirement for a gas certification and had them put in a gas detector in the truck or the trailer, so that's basically sniffing for gas all the time instead of a once a year check. So we thought that was a good idea when we brought that amendment forward, and that's passed through our process. And then the only other thing is adding a fire protection engineer to the board. We were struggling for a long time to fill the electrical engineer position. There's many more fire protection engineers in New Hampshire now, and we thought they would be a great addition to the Board of Fire Control. Initially, we thought about removing the electrical engineer. We finally found one, but we thought adding one more position to the board would be a great addition. So that simply adds FB to the board. So happy to answer any questions.
Thank you. I guess I have one. So will this make the board now be 12 members?
13. Oh, you had to ask that question.
It's like 12.
Looks like 12.
Is it 12? Hold on.
So I guess it's not a huge hang-up right this minute, but I guess my question would be, does
12, sorry.
does the board render decisions where there potentially could be a tie? I mean, we're always concerned with having even numbers of members on boards in certain other boards, and I don't know what the actual authority and
So I actually have concurrent authority on the votes for the board, so I would act procedural sort of things in the board, adoption of rules and things. I mean, adoption of the minutes and things like that. I don't get too involved in that, but when it comes to amendments and any of that process, I do have a vote as well. So I would end up being, I guess, the tiebreaker potentially.
all right, so procedurally, there is a mechanism, so you won't end up with a tie.
Correct.
Okay. That was more my question. Further questions? Senator Perkins Quokka.
Yeah, thank you. And I heard what you said about food trucks and the background, but could you just cover again what the amendment does that was brought? Because it's a big issue in
Sure.
Portsmouth.
Yeah, sorry. Yeah, so instead of having a gas technician come out and look at and inspect the gas system on a truck or a trailer
Yep.
every year, that's no longer be required,
Okay.
and that the operator would have to install a gas detector, which we understand is $50 to $100 on the truck or trailer,
Yeah.
and that would be sniffing for gas essentially all the time instead of relying on that once a year inspection.
Okay.
So, and we believe it's a slight savings to the operators based on what we found.
So for the
Great.
clarification for the committee, because I know I'm confused and maybe I'm the only one.
Sorry.
The amendments that you're discussing are part of section 2 of the bill where we're ratifying the amendments that you're bringing to somewhere else, not to us. These amendments don't come to us.
Correct. So the process that we have is someone would bring an amendment to the Board of Fire Control. The Board of Fire Control has a public hearing and gets input from the stakeholders at that point. We, at the Board of Fire Control level, vote to approve or disapprove of the amendment. And then it's also signed off by the Commissioner of Safety. And then we bring it through to the new legislative committee, comes through the new legislative committee that's made up of 2 senators and 3 reps. And then that gets brought to the full general court for ratification within a year. So the fire amendments are allowed to be voted on at the Board of Fire Control and go into effect immediately if needed. So we try to use that very cautiously, thinking more fire life safety issues might be more imminent than some of the other ones. So, but we need to ratify anything we do at the Board of Fire Control level within 1 year with the House and the Senate.
Got it. All right.
That answers the
Because
question.
I was looking for amendments and we didn't have any, but now I understand.
Yeah, I'm happy to provide the full language with you if you'd like.
No concern on my
Okay.
part. Senator Carson.
Thank you, Mr. Chair, and good morning, Mr. Toomey. This is all part of this system that Representative McGuire and I put together, and it's working great. And I would like to point out the first part, it's a state building code ratification of amendment. And I'm glad you outlined that process for the other committee members, that they understand that it's not necessarily an amendment that
Yes.
we will get here that you want here. It's something that's already gone through the building code board. They've already looked at this. They have recommendations. It's gone through a committee here in the House. And what we have really in front of us is the end product of all that deliberation. So, and I appreciate this document as well, because it lets us know here, and thank you for the opportunity to review those amendments, and there can be pretty extensive sometimes. But it was done this way so that by the time it got here, everybody was in agreement, everybody understood what was going on, and we're just the last step on the ladder.
Yeah.
And we decided that the House, they're the ones that really has a lot of the expertise in these issues rather than the Senate, so that's why the bulk of the work was done with them.
Yes, thank you,
Am I
Senator.
correct?
Thank you, Senator Carson. Yeah, we've done, I think with your help and Representative McGuire's help, I think we've come a long way over the last few years to streamline the code development process in the
Yeah.
state. to look at the model codes that are developed nationally, see how we have to New Hampshireize them if we have to. And there's two boards that do that, and then exactly right, we bring them to you for a final ratification vote, and I think it's working pretty well. So
Further
Thank you.
questions? Seeing none, we thank you for your testimony.
thank you.
Appreciate it. Philip Sherman?
Mr. Chair, members of the committee, my name is Philip Sherman. I'm the chair of the Building Code Review Board. Thank you for the opportunity to speak. I support this bill and will limit my discussion to the building code portion of the intent. So the Building Code Review Board is pleased to forward 8 building code amendments to the current New Hampshire State Building Code with our recommendation that these be ratified. I would note that we have a different ratification procedure currently than the fire code, and that ours do not go into effect until ratified by the general court, signed by the governor. So the purpose of this bill is to proceed with that ratification. These amendments have been reviewed and approved by the board after a public hearing and include 3 amendments which relax energy requirements for changes of occupancy. That's a reduction in cost. 4 amendments that came out of a substantial study done by us and DES last summer about grease interceptors, and we worked cooperatively to try and divvy up where the authority and line of control on that went. We wind up with some amendments. They will wind up with some administrative rule changes to formalize that. And lastly, an amendment from the solar industry. There was a glitch when we adopted the 2018 codes in that the requirements for rooftop solar panels essentially sit in the fire code. The model code has them in the residential code, and we neglected to take them out of there. So all that amendment does is remove it from the residential code and refer to the fire code, which is where the commercial stuff went anyway. A 9th amendment involving flood zone requirements was not approved by the board. That may come up again under the next code cycle. They're looking at that in more detail. This went through the Standing Legislative Committee and then through the House ED&A with no opposition that I was aware of. So thank you for your consideration. Happy to answer any questions, and I have a package that includes the amendments that I can submit.
Awesome, thank you. Questions from the committee? Senator Perkins Quoker.
You answered one of my questions at the end there, which is that we would love to just see that list so we
Sure.
can have it available to us when we're voting.
It's on the way.
Thank you so much. And then, similar to the question that I asked Marshall Toomey, could you just speak again about the change concerning solar, just so I fully understand it?
We start, as Fire Marshal Toomey said, with model codes that are written by an outside organization, primarily the International Code Council. In their cycle, the requirements for solar panels for commercial buildings sit in the fire code. We don't adopt their fire code. The State Fire Marshal and the Board of Fire Control through the legislature adopts a different fire code. They have provisions. So we didn't have to do anything on the commercial side because it was never in our code.
Taken care of,
It's in their code.
Yeah.
The residential code is basically, on some of these issues, an extract of other codes. So they want to get it all in one book so a small contractor purchases one book. That had the International Code Council's requirement for solar panels in it. And we simply didn't catch the fact that we should have deleted it and referenced the fire code requirement. So that's all this amendment does.
Okay, and follow up.
Yes.
Maybe I'm not following you 100%, but it sounded like what you said was commercial was dealt with in the fire code, which was adopted, so you didn't need to do anything. Residential was in some sort of ICC best practice manual, but then I didn't track how the residential solar kind of got adopted into our code.
So we refer to them as model codes.
Yeah.
They come to us in a book, and as
Yeah.
Fire Marshal Toomey says, we
Yeah.
New Hampshireize them. So
Yeah.
we write amendments where there are specific
Yeah.
needs, either statutorily or to save cost or whatever the
Yep, I've
process
seen
results
those.
in.
Yep.
So the ICC requirements for solar panels are more restrictive, providing, I'll call them firefighter access aisles on roofs.
Yep.
These being relatively small buildings, the state fire code loosens up those restrictions. So
Okay.
it makes it easier to deal with We never really intended to tighten up those requirements. They just kind of came with the package, and it wasn't caught.
Okay,
It's
all
a
right.
thick
that's
book
helpful.
with a lot of stuff in it.
Thank you very much. Yeah, it's dense stuff, this code stuff.
Further questions? Seeing none, thank you.
Thank you.
I have two other folks signed in favor, Gary Abbott from the Associated General Contractors and Adam Schmidt from the New Hampshire Association of Fire Chiefs. Is there anybody else that would like to speak on the bill? Seeing none, we'll close the hearing on House Bill 564. I'm sorry? Yeah. Senator. Yes, I saw that this morning. I didn't get a chance to read it. Would you like to go for the trifecta?
We really need you today.
Philip, you have the sheet for this one. Okay.
We did this already. This is one we did in the budget, and then we had this bill last year. One person, this person here, was the sponsored bill, and it covered the veto. Why do we have it again?
All right, we're going to open the hearing on House Bill 127, and I'm going to ask Senator Gendro to introduce the bill.
Thank you, Chair and honorable members of the committee. For the record, my name is Carrie Gendro, Senator for District 1, and I'm here to introduce House Bill number 127, and it's relative to the declaration of a state of emergency. This bill revises the authority of the governor and general court to declare, renew, or terminate a state of emergency.
Thank you, Senator. For the record, the prime sponsor, Representative Leck, was not able to attend and did send testimony to the committee by email. Melissa Lasik. Former rep, and good morning, honorable.
Thank you, Mr. Chair, members of the committee. Representative Lakis sent me with his testimony. He did submit it to you. I don't know if you'd like me to read it. I can certainly, and I'm also here to answer any questions if you have any questions about the bill.
If you'd like to read it, that's fine.
Sure. When an emergency strikes, the governor needs the power to deal with the situation properly. This bill permits the governor to maintain his emergency powers for up to 84 days without requiring the legislature to meet. Emergencies have more than one phase. There is the initial phase, which requires quick and decisive action, which the governor is better suited than the legislature. However, after the immediate problems have been dealt with, the emergency transitions to a management phase, where there are still serious problems that may last for a long time, but the situation does not require the same level of urgent response as the initial phase. After the initial phase, the people of New Hampshire need to be involved in the process through their legislators. If the legislature believes that the state of emergency should last beyond 84 days, it may vote to renew. Concern has been raised that there may need to extend the state of emergency, but that it might be impossible for the legislature to meet. Even during the recent emergency, the legislature was able to meet in less than that amount of time. We have shown that we have the creativity and flexibility to meet and do our duty, even under difficult circumstances. While current statute permits the legislature to meet and vote to end the state of emergency, there is a significant difference between the legislature having the power to meet to end the state of emergency and it being required to meet to extend one. Meeting and voting to extend the state of emergency makes it clear to our constituents that we are doing our job representing them rather than sitting on our hands and leaving that responsibility to the governor. Any of the bills that we vote on will require a majority of the House and the Senate as well as the governor to become law. A state of emergency ceding the role of this legislature to the governor is a much more serious matter than anything we will do in session. Should that action require anything less than the agreement of both the House and the Senate? Part 1, Article 37 of our Constitution states, in part, quote, "In the government of this state, the three essential powers thereof, to wit, the legislative, executive, and judicial, ought to be kept as separate from and independent of each other as the nature of a free government will admit. A state of emergency is a truly extraordinary thing. It is the suspension of this constitutionally mandated separation of powers. While that may be necessary to respond to an emergency, after some point in time, it is no longer justified, and the legislature must remove its constitutionally mandated task of guiding the way any remaining problems created by the emergency are managed. That must be an active role, not just standing aside and acquiescing to whatever the governor chooses to do, which current statute permits. Also, if the state of emergency does need to extend beyond 84 days, the legislature should have the governor's back and actively declare its support of how the emergency is being handled. If there is opposition to the state of emergency, we should share in the blame or credit of extending it. That is our responsibility as representatives of our constituents. Legislation affects the future. This bill is not a referendum on how the recent state of emergency was handled. Even if we believe that the current governor handled the recent emergency perfectly, we need to consider the possibility that a future governor may respond in a less appropriate manner.
Thank you. Questions from the committee? I guess I have one.
We have seen the bill before, so.
Yeah. So I guess I'd like just your thoughts on page 1, line 15, that the governor declares an emergency for 21 days and the general court does for 90 days. Could you explain to me the thinking between the two different time periods?
So there are two ways to declare a state of emergency, right? So either the governor may do so on his own, or the legislature may meet to declare a state of emergency. So it's one person versus 424, right? So if it's one person, I don't really see, I see the necessity that they should need to kind of come back to the table more often than 424 people making that decision. But ultimately, they are the same, right? It's 89 days to 90 days because he may declare and renew 3 times without permission from the legislature. So ultimately, it becomes the exact same amount of time.
Didn't introduce your side.
Oh yeah, this is my sidekick. This is Natalie.
Hi, Natalie. Did you want to speak too?
What do you think about state of emergency reform? Okay,
Sorry,
we've now
I didn't mean to
embarrassed her.
embarrass you. I'm sorry. Any further questions? All right, seeing none. Thank you.
Thank you.
Aubrey Freeman.
Mr. Chairman, committee members, Aubrey Friedman from Bridgewater. I speak in support of this bill. I've been waiting for a bill like this for years. And we need to, the important thing about this bill is, okay, they have states of emergency, that's fine, but to limit it. And of course, as was mentioned, well, we know from the last 3 years, it went on and on. So that's the problem. And so this bill handles that problem. You've got to have a time limit, a specific end to it, and currently the governor can extend it unendless, just go on. And so this definitely limits the renewing of it to 3 times. So that's critical. One person cannot have the power to just continuously extend a state of emergency. This has nothing to do with party affiliation or the personality of the governor. This is to limit the office. If you look at what happened over the last 3 years, the 50 states, was quite a variety. We had some governors that were pretty good about keeping their powers in check, what they thought their authority was. And we had others that went crazy with power lust, and extending these emergency over and over again. So, plus, as was mentioned, you might have a governor who's, pretty on top of things and doesn't get too crazy with power, but the next one might be really authoritarian. So this is to set the position, have nothing to do with personalities, just the job, cannot do it more than 3 times extending it. And this bill also takes a lot of that power from the governor and his executive council, gives it to the legislature. As was mentioned, that's 424 people. There's still a potential for tyranny here because just 424 can, you can still have mob rule, but the chance that it's spread out, rather having concentrated power in one person and his council versus 424, the likelihood of things getting out of control with as far as getting too authoritarian is much less if it's spread out. And plus, of course, the representatives and the senators are closer to the people. You know, I mean, I can send an email to my rep and they'll probably respond. I mean, would you bother to the governor? He's covering the whole state. Again, I don't mean him personally. It's just the whole idea of concentration of power versus diffusing it. So I think we just have to get this right for the future and make sure this can't happen again. And that's why I support this bill.
Thank you. Questions? Seeing none, we appreciate you coming in.
Thank you.
I have one other person signed in support, Carolyn Virtue from Granite Case Management. Anybody else that would like to speak on this bill? Seeing none, we'll close the hearing on House Bill 127. I'll accept a motion to go into exec session. All in favor?
Aye.
What I'd like us to talk about first, because I know we had some concerns yesterday, and I apologize, I have to find the right bill. Bear with me a second.
Oh, was that the one that we talked a lot on?
594, 594. No, we have not moved 594 forward, I don't think. No. This is the one on, excuse me, on reciprocity. I'd like to invite Director Courtney to come up and talk with us, because I know the committee received a lot of testimony yesterday. And I think we may have a couple of questions that OPLC could help us answer.
Thank you, Mr. Chair. Members of the committee, Lindsay Courtney, Executive Director, OPLC.
Thank you for coming in. I know I messaged you and asked you to come over because I know we heard a lot of issues on this. Some of them related to placement of where we were putting this language as far as it pertains to 332 G14 and how one section would supersede another if it was passed later. And did you have the opportunity to hear that testimony or review it and understand what some of the concerns were? Or?
I do understand the concerns. I didn't review that testimony in particular, but I did talk to staff members who are here.
Okay. Any thoughts on the request that we had about changing some of the language to include what was in 332? And I'm trying to find my right piece of paper here. There it is. So we had a request to consider, you probably don't have a copy of 332 G14 Section 2 right in front of you, but the language says any board or commission may determine that another state's licensure is not comparable to New Hampshire's in education, training, experience, or scope of practice. Seem to give a little more definition rather than just substantially similar. Would there be any concerns from OPLC if we were to adopt some language similar, include that language into, rather than substantially similar, or maybe in addition to?
No, we don't have any objection to that. I think it clarifies what substantially similar is intended to represent.
Okay, I know that was one concern that I had written down. And one other thing that we talked about and we heard as a concern was if we pass this, it essentially gives OPLC the authority to decide if it's substantially similar and sort of directs the boards to issue these licenses. If the board were to disagree that a different state's requirements were substantially similar, with your ruling that it was, the OPLC's ruling that it was, we talked about, or I suggested maybe an appeal process for the boards. I guess, could you speak to us a little bit about your thoughts on that, if there was a conflict between OPLC's ruling of substantially similar and the boards?
So I think practically the way it would have to work is that we would have to promulgate rules defining what is considered substantially similar. Because we wouldn't be able to just say Maine is substantially similar, Florida is substantially similar, because those states' licensure laws are constantly evolving as well. So we would have to go through the rulemaking process, which would necessarily allow all interested parties, not just the boards, an opportunity to comment and certainly have to be approved by JailCar. So to the extent that I think there was a disagreement, I think JailCar could certainly resolve that dispute. We took that approach with Massage. Massage is an advisory board, and within those rules, we outlined what we would consider to be substantially equivalent. So, because many states have fewer hours requirements than we do, and that was the approach. And so, as states change their licensure laws, we can adapt in accordance with our rules.
I hadn't even thought about that nuance. Thank you for bringing that. So you feel that through the rulemaking process, you could use JailCar as that appeal process?
Yes, I think we'd have to look at our statute and rules and say, you know, if our statute requires 1,500 hours, working with the board, we think 1,200 hours would be sufficient. And then when we receive applications from another jurisdiction, from an individual who's licensed in another jurisdiction, determine what laws applied at the time they were licensed. Because it's not also the existing licensure laws, it's whatever was in effect at the time they obtained a license.
I'll open it up to the rest of the committee if they've got any questions. I think that answers the main ones that I had. Senator Perkins Squilka.
Just to further entangle us in this web.
Yes, the can of worms, as we talked about yesterday.
I think one of the concerns that's been raised both under 594 and 655 is just respecting the work that's been done by the boards that have made rules, you know, under 332 and other places. So I appreciate procedurally what you're saying in terms of the appeal. Would it be fair to say that in cases where boards have made rules or determinations about which substantially similar, JailCar has resolved the issue in those cases, and so we're really just trying to figure out how to grandfather those existing rules?
Yes.
Long question, sorry.
No, I'm not aware of any board that's made any determinations under 332G in rule. There are other endorsement processes that I think wouldn't be impacted by this proposed statute, such as compacts or specific reciprocity language within their statute. But 332G was a different analysis that boards have just not undertaken for various reasons. So if they had made that, if they had undertaken that analysis and JailCar had gone through that process, we wouldn't see a need to upset the apple cart. This is really just a mechanism to ensure that all professions have undertaken this analysis.
Okay, I think that answers me.
Okay, Senator Costa.
Thank you, Mr. Chair, and good morning, Director Courtney.
Good morning.
We had testimony yesterday from the realtors, and they made a really compelling argument that most of their rules are New Hampshire orientated as opposed to, you know, Massachusetts, where their realty requirements for licensure are really directed towards their laws. Is there a way to carve them out of this process in other boards that are really focusing on specifically New Hampshire law, as opposed to, say, someone who is a nurse and their scope of practice is really general? They all have the same requirements.
Yes, I've spoken with the Realtors Association about this particular issue. We don't view the New Hampshire licensing requirements to be substantially similar to other states' licensing requirements. And I think so when we would undertake that analysis, we would just say, obviously, in order to be substantially similar, you have to have a knowledge of New Hampshire licensing requirements, and no other state has that requirement. So there are no states that satisfy that requirement. I think off the top of my head, appraisers may be in a similar bucket. But rather than providing for exemptions within the statute, I think it makes sense to have that done through rulemaking in the event that our requirements change or other states' requirements change. We can respond to those requirements.
May I follow up?
Yes.
I got the impression that the gentleman that came in from the Realtors Association was very concerned about this, because I think there have been other attempts for reciprocity with the realtors, and it's basically the same argument, and I think that they would feel more comfortable having it in statute as opposed to rule. And so that's why I'm wondering if we can get a list from you with the, they're not organizations, but the boards, that their licensing requirements are really orientated towards New Hampshire and our laws, as opposed to more general, practical types of boards. So we can exempt them in statute.
Yeah, we can certainly provide you with a list. I think part of the issue and concern is that most of the boards haven't undertaken this analysis. So we have to do that in the first instance in order to provide you with the list. Off the top of my head, I can probably give you a list, but I'm not sure that we would be as inclusive as we need to be. Real estate, I can 100% say meets that criteria, but with respect to the others, I just don't think we've undertaken that analysis.
May I follow up?
Yes.
Thank you. Well, we've got some time,
Yes.
especially with this bill. I believe because this is a fiscal note bill, it has to be on the floor May 18th.
Okay.
So we have well over a month. So hopefully in that time, you can get us that information and we can get an amendment and exempt those very New Hampshire specific boards, and it'll give them some peace of mind. So,
Certainly.
Okay.
Happy to
Thank
do
you.
that.
So if I'm going to build on what Senator Carlson was just talking, or perhaps ask a question related to that, and I maybe kind of to both you, Senator Carlson, and to Director Lindsay. If we do this in statute with an exemption, and there were to be something that changed within one of these areas that we exempt, that now would sort of put them back in the bucket with everyone else, doesn't that make it a bit cumbersome to adjust that? Would we be better suited to require rulemaking that clarified that, you know, any license that had a specific New Hampshire requirement would not qualify for reciprocity? Would that be an easier path to get to the same place, is my question.
I think that would be an easier path. I think you would have to make it clear that it's not a New Hampshire requirement. You'd have to say something like, if education requires knowledge of specific New Hampshire laws, something to that effect, then those professions shall be exempt. And I'm thinking some of the technical professions would probably fall into that bucket. I don't think we'll find that the healthcare professions are impacted by that sort of language. It's more of the technical fields.
Well, if I'll just
No,
go
no,
one
no,
more
go
little
ahead.
quick. The only reason I say that is because at any point in time, the legislature could pass a law which all of a sudden puts someone else in this same bucket and they're not exempted.
Right, exactly.
And so that was my thought, but Senator
Right.
Carlson,
Yeah.
go ahead.
Thank you. I take a different tactic because I see that these boards, in the last time that I checked, they go for their just routine rulemaking every 8 years. And that if they want to make changes in rules, it has to be some sort of emergency. They have to apply for emergency rules. I think I'm correct on that because it's been a few years since I sat on JELCAR.
So they can go through the rulemaking process at any time. The rules are valid for 10 years.
Okay, it's 10 years.
If they want to respond to an emergency, then there's a separate emergency rule process. But most boards I take that back. There are a handful of boards that are in a perpetual state of rulemaking because they like rulemaking. Most of the boards just wait the 10 years.
Okay, so may I follow up?
Sure.
Thank you. Thank you, Director Courtney, for that clarification. I think it's better to be in statute because I look at the rulemaking process where you've got to have the public hearings, and just like we have to have the public hearings, and the boards have to make decisions. There are amendments, much like committees doing the same thing. I just see them going this way, and I think statute, as we all know, trumps rules. Mm-hmm. So there are going to be some boards that are just really focused on New Hampshire law, and I don't believe that is going to change. And I think that it is going to help them be a little more comfortable with the idea of reciprocity if they know in statute that they have, that they're going to be exempt from the reciprocity agreements, because of the nature of their job, that they're not going to have to constantly go back for rules over and over and over again. It's in statute trumps rules, and it's, to me, it's a cleaner, more clear way, because one of the comments that we had, and it came from Mr. Rancourt, is about consistency and about transparency and being clear. And I think having it in statute is much clearer. Most people, if they want to research, they're going to go to the statute. Rules can be very cumbersome and very difficult to go through. And a lot of people just, unless you're really focused on the rules, they're really not going to look at rules. They're going to be looking at the statute. So that's why I think statute will send a stronger statement, easier to find, very clear, and take it from there. And if anything needs to change, they've got to come back to us, just like with the board. They've got to come to you, and you've got to go through that whole process. So.
Certainly. So what I can do is get you a list of what we think satisfies that standard. I think, to Senator Pearl's point, you could also include additional language to the extent that there are other professions that are not regulated now that are regulated in the future. I could provide you with suggested language if the committee, we're not taking a position on that, so whatever the committee would like to do, but we can provide you with suggested language.
I think that'd be very helpful.
Thank you.
Yep, you're welcome.
Thank you.
Can I just comment? Okay.
Senator Dendro.
Just to kind of build on the real estate end of it, which is very unique. If somebody, let's say Senator Perkins Coca wanted to go for her real estate license, she would have to now take a 40-hour course. That's required, 40-hour course. And then there's two parts to the real estate test. One is what they call the universal test. That's all across the United States, everyone takes the same test. Then there's the second part where you have to take the state test, which I think that consists of like 30 questions. So if let's say she was living in Massachusetts, has a real estate license down there, but then wants to start practicing in New Hampshire, all she would have to do is take the state portion of the test in order for her to get her license.
And that's current practice?
That's
Yes.
current.
Yeah.
Yes, correct. So I think just to clarify that it's already a well-oiled machine, and they've been doing that for decades. Now, you used to be able to send in $25 and get your real estate license. This was back in the 50s, and they grandfathered that in, but they've made a lot of changes. But there are two very distinct tests that potential candidates have to take. So that kind of eliminates, so the universal test is good. That's not even state specific, but each state has their own laws, so.
Certainly.
Any further questions?
Thank you for your time. I appreciate
Well,
it.
thank you. Appreciate you coming in.
Of course.
All right. I didn't feel we were ready to act on this, but I thought the committee had a lot of questions from the hearing yesterday, and I thought this would be a good way for us to get some of them answered, so. Okay. We have a list of bills that we heard. I think we took care of all the bills that we heard yesterday that were ready, we felt were ready for executing. Would all agree with that? All right.
Mr. Chair, if
Yes.
we're going to start doing this, so if we can take up a bill that I believe we heard today, House Bill 564, relative to the ratification of amendments to the state building code. I think that's, if I may, Mr. Chairman, I'd like to move on to pass.
You certainly may. I was going to suggest we do that. Do I have a second? Second. Second? We have 2 seconds, so take your pick.
I think this bill is very clear, and as I said to Fire Marshal Toomey, Representative McGuire and I have worked with these boards for a couple of years to get a streamlined process for the adoption of amendments, because oftentimes they come to the Senate and we just did not have the expertise. The House are the ones that really have that. So we developed a process in which they would begin in the House, that these boards would go through a process, adopt their rules, and then come with us with the proposal through legislation to the House Committee. And that's exactly what they've done. It has streamlined this process. No angst, no difficulty. It's working, and so I want to thank both Mr. Sherman and Fire Marshal Toomey for helping us get through this process. So in my opinion, this bill is ready to go. We don't need to make any changes, and that's why I moved on to pass.
Further discussion? Seeing none, all in favor?
Aye.
Anybody opposed? Seeing none,
I will take this one.
Senator Carson will take this out.
Okay.
Unfortunately, today, none of these bills can go on consent because we only have the four of us, so
Do you know, is she just not here?
she's
or-
not here today.
Okay.
Yeah, she's in the hospital with my mother.
Oh,
Oh,
I'm sorry
okay.
to hear that. Okay.
Same.
We're sending her our best wishes. Hope everything is okay.
Staying on today's hearings, how about House Bill 358? That was the very first one we heard. I don't
I,
recall there was any issue with it, but let's take a look.
well, if I may, Mr.
You certainly
Chairman, I have some concerns about the waivers citing authority. I think we need to get some clarification on that to find out just exactly what is happening here. Usually if someone gets a waiver, there's a specific reason why they're asking for a waiver. And I don't know if that extends the authority of a department to use that waiver in a different manner. And I think I think it would be interesting to get someone who issues those waivers, and I'm not sure if it's Gelcar, to come in, and maybe one of the attorneys from Gelcar
Okay.
to talk about that. Because if departments are using that waiver, I don't think it's appropriate. Again, waivers are for a particular reason and shouldn't be used. We give them authority through 541A to adopt rules and, create forms. And sometimes it's, like I said, it's a blanket one where we're not gonna micromanage. Sometimes it's more constrained. And we need to find out exactly what's happening here. I think Ms. Virtue brought up a number of very interesting points. And right now, Mr. Chairman, I don't think this bill is ready to come forward.
I would agree with you. House Bill 127, where are we on that one? This was the last one we heard about the state of emergency. I know we've seen this bill before.
Yes, I will tell you, Mr. Chairman, we saw this bill before. We saw it last year in ED&A. And we were told that we had to pass it because there was an agreement made between the governor and who knows. I tried to find out, because if someone is going to say that there's an agreement, I want to know who made the agreement, because I know as the chair of ED&A, I did not make any agreements with anybody. So I couldn't track it down, but we felt at that point, we're just gonna pass it, and the governor vetoed it. So I think we're probably facing the same thing, where if we pass this, the governor's gonna veto. In the first year of the biennium, we did put in language in the budget that dealt with the governor's powers. I don't know if we need this, quite honestly. If I remember correctly, in his veto statement, he felt that it was not needed. So I don't know. It does limit the office, I don't want to say his, it does limit the office's authority, and I thought that at the time, it was an agreement between the House and the Senate, and everybody was on the same page, so I was surprised to see something come forward again. And do we want to restrict the power of the executive branch that much? There has to be some wiggle room. It can be fairly difficult in the state of an emergency to get 424 people together and on the same page. Sometimes you have to trust the leader, and the leader of this state is the governor. And that's why things were done, I believe, for 90 days, and then the legislature kicks in to be that check. And don't forget, you also have the executive branch as a check on the governor as well. So I'm not sure that we actually need this, but everyone's gonna vote the way they're gonna vote.
So I was in the House when this bill, when the discussions were being had. I was not part of the discussions, so I could only give you an explanation from the perspective of, it was secondhand information to me as to who made the deal.
I have no, still to this day, I have no idea.
Well, I think, I mean, I certainly know what I was told, but I don't want to represent it as fact since it wasn't told to me firsthand. And so my suggestions would be, I mean, I understand the premise of the bill in having a check on the power of, you know, the governor to essentially put the state in lockdown. I got it. I understand what the concern was. And I certainly could see how in the wrong hands that could be abused. I don't know whether we need this or not, and my suggestion would be if we decide to do this, I think the biggest change I would make that might not get it vetoed would be to change the effective date from effective upon its passage to at least July 1st of 24, if not September 30th of 24, which would then push us through the current administration's tenure, and that might help it not get vetoed. I know that was one concern. But I don't know if that's, again, I'm not 100% convinced we need it, but I certainly do understand the premise behind it. Just thought I'd weigh in with those thoughts. Anybody else want to weigh in? Senator Purr.
I'll weigh in briefly just to say, you know, I tend to agree with most of what Senator Kirsten said. I don't think we need it, and as the witness said, this doesn't really represent a big change. I mean, we're talking about the 90-day period essentially either way. So I think there's some things that need to be done in an emergency, and we can all acknowledge that. So I have no concern not passing this year.
Would you like to weigh in, or any thoughts?
No, I guess I'm sharing the sentiments of you all. I know some of my constituents have said, why does the governor have that much power?
Mm-hmm.
So, and I almost like everything I've heard, I almost like yours, Senator Pearl, the best as far as changing the effective date out there. The worst that could happen is that the governor still vetoes it, but it puts it into another potential administration. Those are just some thoughts.
Yep.
If I may,
certainly
I understand that there were a number of people that were very angry with the governor for his actions, but you had to have somebody make decisions. And that is the job of the governor. Mm-hmm. You can be angry with him, you can be upset, and because we are talking about Governor Sununu, because you're talking about extending this out until his term is almost over. Mm-hmm. So you're sending a message with that. I mean, you don't have to be a rocket scientist to figure that one out. And I understand it. I have concerns about legislation that's targeting one person as opposed to the office itself. And I think we just need to realize that hopefully we will never see something like this again in our lifetimes where someone had to make that kind of decision. But that's what we elect a governor to do. They are the leader of our state. And he did what he felt was appropriate for the time and the circumstances. And there are people out there that do not agree with how he handled the situation. But he is our leader. And, you know, I get it, I understand it, but I just feel that if he's going to make, or any governor is going to make a decision, they're doing it in the best interest of the people, to help the people, save the people. They have the duty of care for the health, safety, and welfare of the people of their state. I would hope I never, ever, ever live to see a candidate for governor violate that, because that truly is, I don't know, twice maybe? I'm not sure, once or twice after this, that the people of the state, the majority of the people, had confidence in what he was doing. And so I just don't see why we need to restructure this. We already took care of it in the budget 2 years ago. We addressed everyone's concern, and so now I just see another tweak. And what really does that tweak do? What does that tweak do? And I'm just really not that sure what it does.
So currently, the legislature may terminate a state of emergency or any emergency order issued thereunder by a majority of vote, this is current law.
Right.
By a majority vote of both the Senate and the House of Representatives.
Correct.
It's changing it to a concurrent resolution adopted by a majority vote of each chamber, which essentially doesn't change anything.
Right.
That part of it.
Yeah, so, okay, so that does nothing.
Again, it moves it from a majority vote to a concurrent resolution, which you gotta have a majority vote to pass a concurrent resolution, so
Right.
it's
and-
wordsmithing a bit.
And the reason why it was a majority vote of each chamber, and I sat on this committee at conference, was because of the difficulty in the state of emergency of getting people together. You might get out of 400 representatives, you might only be able to get 200. But it's going to be a majority of the people who are present, rather than 3/5 or whatever, or 2/3 of how many are supposed to be there. So again, I strongly feel that those issues were already addressed in that legislation that was passed 2 years ago.
Because the second thing this does is it removes provision D on page 2, which 90 days from the date of declaration of the state of emergency, and every 90 days thereafter, the governor shall call pursuant to Part 2, Article 50 of the New Hampshire Constitution, and address a joint session of the general court, and shall provide a written copy of the address to all members of both chambers within 5 days. At such joint session, the legislature shall vote on whether to terminate the state of emergency. So you've already got a provision where he's coming in. Every 90 days, he has to call the legislature
Right.
in. It-
Right, and
It just changes the process.
Right.
And it doesn't really move the bar.
my concern here with the exclusion of this language, again, they're asking for a concurrent resolution adopted by a simple majority of both chambers acting separately on the following question. Why would you take that away? Because again, I think it reflects the fact that you might not get everyone there. You
Right.
just might not. So why would you take that language away?
Well, you don't get everyone there in a normal time, never mind a state of emergency.
Exactly. So here it says, again, adopted by a simple majority of both chambers, and it speaks to actually terminate, shall vote on whether to terminate the state of emergency. Why you need to remove all of that language, just, and I know that it's restated here, so
It's moved into a different section, that's all.
why? It's just moving things around. And for what reason? I didn't hear a reason, Mr. Chairman, for why we need to move this language around. What's the purpose of it?
We've had a good discussion. Anybody want to make a motion?
I move ITL.
Okay, further discussion? All those in favor of ITL?
Aye.
All opposed?
I'll take it out.
And Senator Carson has agreed to take it out. All right. I think it's all of today's bills, right?
Yep, I think so.
Okay, so let's go. We've got about 40 more minutes. The big bill that we have is House Bill 655. I don't know, what are your thoughts on all of that? Got it. I don't know if we're ready to move this forward or not. I've got a ton of notes on it and things that want to be changed, and I will say this. One concern that I have with making any changes in 655 is we've got a clean bill that's through the House right now. If we choose to accept it, it will go to the governor's desk, and I'm quite confident he'll sign it. If we make changes, it has to go back for a committee of conference. I'm not so certain what the fate of the bill would be at that point in time. We do know the close makeup of the House. My thoughts might be to allow 655 to move forward as it is, and any changes that we wanted to make that might be relative in the language of 655, we perhaps do in a different bill that we're going to amend. That is one thought that I had.
if I may, Mr. Chair.
Yes.
My concern is what's happening with the budget.
Mhm.
And I know that some pieces concerning licensure were still kept in the budget, and if they fail to pass a budget, that stuff goes away until it comes to the Senate.
Correct.
And I'm not sure, we're looking at a cleaner method, is to take that language out of the budget completely
Yes.
and put it here.
Well, my thought isn't to put it here, it's to put it in a different bill, so that,
Have you found one?
yes.
Okay,
And my thought is, we leave 655 alone, it's got a lot of really good things in it. There may be
Yeah.
one or two tweaks that we want to make. I know there's been a couple of requests, but those could be handled in a different bill.
Procedurally, I have no objection to what you're doing, but I do think, or what you're proposing, I do think the changes to complaints and investigations, you know, the sort of volume of civil procedure concerns we heard on that, is something that I just do want to make sure we address. And I've spent some time trying to understand what the existing rules are there. So I'm ready to be helpful, whether it's in this bill or another bill, but I just, you know, these are people's livelihoods,
Understood.
and I want to just make sure that we've got the right checks and balances in that process.
And my commitment would be to address those as well. I'm just thinking if we leave 655 alone, we've got something that goes through and the governor will sign it. And then we can make our changes and address those concerns that we have in a separate vehicle.
Okay, and then as far as the licensing pieces in HB2, I guess we have to see what happens today, but I'm still getting a lot of feedback on those.
And we have
Yeah.
that same vehicle.
Yeah.
My original intent
Yeah.
was to use 655 as the vehicle to remove all of basically anything OPLC related out of House Bill 2 and put it in 655. That was my original intent. But in rethinking that and having some further conversations, I think 655 has a lot of really good value in it the way it is. And if we let that go through and we use a different bill as a vehicle, I think that I think it's a better path forward. It gives us something that we know for sure we've already got on the table, and we don't have to send it back to the House with the uncertainty that it won't make it through, the changes we make.
my concern, Mr. Chair, is really about clarification and transparency. About, you're gonna pass things in here, and then you're gonna take another bill, and you're gonna make the changes that needed to be made here in that other bill. And whatever additions or anything else, and you could have them go like this. So we can certainly pass this. I support this, but I understand what Senator Perkins Polka is saying.
do
I'm very concerned about what we're gonna try to do here, because we can pass this and then try to fix it in another bill, and what happens if that bill fails? And what are the ramifications? Because you're gonna face that same situation with, oh, they took my bill, they amended it, we're gonna go to a committee conference, versus in here. So, I'm very hesitant to do that.
So I will say this, the changes that we were looking at that were in House Bill 2 is going to require a non-germane amendment, which is going to require a separate hearing, whether I put it in 655 or in any other bill. So just understand it.
Why is it going to be non-germane?
Because there are some changes that are not germane to 655. This is a conversation I've had with our Senate President, and he's in agreement.
Okay.
And so my concern is, my point is, we're going to have another non-germane amendment hearing, whether it's on this bill or on another one. This is the reason I heard this so early, was because that was my intention. But, so, I'm not pressing it, I'm offering a suggestion to a path forward. If the committee's in agreement, we can address it. If you want to hold a little bit, we can. The only thing I'm trying to do is get some of the FMs out so we can get them on the calendar. If the committee isn't ready to do this one today, I'm okay with it.
Yeah, Mr. Chairman, I'd like to think about
Okay,
that.
fair enough.
Basically, I'm really waiting to see what they do upstairs today.
And I don't disagree with
What an amendment is going to look like.
I was hopeful that we were going to have a day next week that we could exec and get it on an amended calendar, but we're not.
Oh,
So
okay.
anything that we don't exec today is not going to be on the Senate floor until the first week of May,
Okay,
okay?
yep,
And
okay.
I'll
Just
just
as an FYI.
offer as a final comment, there were a bunch of, I thought, smaller, valuable comments to hear. And so I've started working on an amendment, but my intention is to combine that with whatever efforts the rest of the committee wants.
And I'm good with that. I was
Okay.
just throwing out a suggestion.
No, I hear you.
All right. House Bill 30. We'll go back to the ones we heard 2 or 3 weeks back.
So, Chair, if I may,
You may.
I have a suggestion, but I don't know what others will feel. So we've gotten, I mentioned that there was a bill we saw in election law that talked about participation in the retirement system being optional. We've seen HB 30, and then we also had, I think it's HB 461, which contains the penalty, for switching a full-time position to a part-time position.
Yes.
It would be my suggestion that this issue kind of needs to be studied, because I'm hearing really disparate things about whether this is a widespread problem or not. And, I think the intention is to avoid us double dipping. I think we all value making sure we have contributions to our retirement system. We don't want to see employer contributions drop willfully, but I also am just really concerned about tying the hands of our municipalities in terms of, like we heard, hiring back retirees into full-time positions. So that doesn't all need to necessarily implicate HB 30, but they're all on the same subject. So I'm just offering that as sort of a thoroughness point.
I think I was comfortable with 30, but I do understand your point
Yeah.
with 461.
Why they got sent someplace else, I don't know.
Yeah, there's one
That's
bill.
weird.
I know, I need to figure out its number. I don't know why one
Yeah.
came to Elma and two came here.
If I may, Mr. Chair, ED&A has seen bills like this before,
Okay.
and we have passed them. Hasn't been an issue. There's usually a reason why that they're hiring them coming in from someplace else, and they've got a 401k, and in order to buy into the retirement system, it would cost a pretty chunk of change in order to do that. So many of these folks being hired by the counties, they just keep their own, and they negotiate whatever they want for their salaries, but they need that exemption in order to do that.
Yeah, and just to be clear, I'm fully supportive of leaving that option to the town. So if you guys are comfortable with HB 30, I am too. I just was trying to think holistically about the issue.
I accept the motion.
I'll move on to pass.
Do you have a second?
I'll second.
Further discussion? Seeing none, all in favor of HB 30 ought to pass? Aye.
Aye.
Any opposed? Senator Perkins Coker, would you like to take this?
Yeah,
one?
sure.
And I'll help you over the rough spots.
Okay. House Bill 109.
Mr. Chair, I'll move on to pass.
Second,
Ought to pass in second. Discussion.
I think it would be great to allow our physical therapists this flexibility in their practice.
Yeah, I didn't have any notes of opposition to this one.
Nope. And I just reading the reports, and thank you, Phil. I wasn't there that day, so I'm relying on the hearing report. It's cleanup language.
Yes.
It's been 22 years. And I like the idea of removing the requirement for a doctor's referral to receive occupational therapy.
Right.
That's great.
Right.
Further discussion?
Nope.
Seeing none, all in favor?
Aye.
Aye.
Any opposed? Who would like to take this one out? Any volunteers?
Can volunteer?
Did you volunteer?
Sure.
Okay, Senator Perkins Coker.
I don't want to be doing them all.
No, you don't need to.
You don't need to
I'm
do
like,
them all.
but I'll just tell you all, I'm here if you folks need backup.
House Bill 138.
Mr. Chair, I move on to pass.
I'll second.
So, may I speak?
You may.
It's a department request, removes outdated references from state law, deletes the supervision of the clerical staff for the State Board of Veterinary Medicine, referencing its quarantine facilities for contagious equine metritis.
Yep.
We send them out of state. So I think this is basically just a cleanup bill for the Department of Agriculture.
I agree. This won't affect any practice that's going on currently in New Hampshire, and the state vet was very clear that we don't need it. So. Further discussion? Seeing none, all in favor?
Aye.
Any opposed? The ayes have it. I will take this one out.
I was going to say, you were probably going to take it out.
193.
Mr. Chair, I move on to pass.
Second?
Moved and seconded.
May I speak to my motion,
You
Mr.
may.
Chair?
Sorry, I'm trying to get turned to it.
Testimony that this bill was filed at the request of the New Hampshire Retirement System to clean up language. There was no opposition to the bill. In fact, it was kind of an interesting group that supports the bill.
Yes.
So I think this is, we need to do this, just clean it up.
Further discussion? Seeing none, all in favor?
Aye.
Any opposed? Senator Gendro, would you like to take this one out?
Would love to.
Awesome. House Bill 206.
I move on to pass, Mr. Chair.
Second?
Moved and seconded. Discussion.
Go ahead.
No, go ahead.
Senator Perkins Quokka.
I was just gonna say, I think it's great that this bill will expand access to our veterans for a few different benefits by including them in the definition, not least of which is childcare, which is a big issue in my little seacoast economy for our veterans and families. So I am proud that we got this cleanup done so they can have access to that.
I will say honestly, I did not know a Space Force existed, so it was a very interesting bill, and I learned a lot, as I have many days in the Senate. So
They're
I
designing new plates too, to add to that for the badge.
I will,
Cool.
I will be happy to support this.
I think this is just, I had to reread it. Because I knew that they were doing something. I hadn't realized it had gone that far. I know service members are being assigned to the Space Force. Just don't know what the duties are yet. I imagine it's something to do with.
We
here in New Boston as well.
We have a base. Wow, that's awesome.
There was a little bit of discussion, and I'm ashamed to say I can't remember exactly what the duties were, but it was very interesting. So,
Yeah.
further
Yeah,
discussion?
provides defense in space domains such as satellites and other
Yes,
potential
That's
weapons.
what it was. Yes,
There you
I
go.
remember that.
Okay, so
I should read the hearing.
Yeah.
Further
as I
discussion?
said, our aide does a good job.
Seeing none, all in favor?
Aye.
All opposed? None? Who would like to take this one out? I'll let it out for volunteers.
I'll do
Senator
it.
Gendro.
I'll be the space cadet.
You can do it.
You'll be the honorary member of the Space Force.
That's right.
There you go. Maybe you'll get to meet Captain Kirk.
That would be cool.
Yeah.
House
he
Bill
still alive?
262. He is 90
Yes, he
years old.
is. I think he's like 90.
90 or 91.
Yeah.
I move out to pass on 262.
I'll second. Discussion. I guess I'll say, my notes say this was a housekeeping bill and does not expand the scope of practice of the naturopathic doctors. So it was
Yeah.
just a clean up language.
Yep, I have, again, from Phil's good hearing report. RSA 151:12C inadvertently excluded naturopathic doctors from the list of licensed medical practitioners who are authorized to order and interpret labs in New Hampshire.
Yes.
So,
Further discussion? Seeing none, all in favor?
Aye.
Any opposed? Volunteers on this one? I can take it out. I'll take this one. They'll give me a couple. House Bill 325.
we want to pass?
Second?
Moved and seconded. Discussion.
Well, there were no speakers other than Representative
That's correct.
Senator Gendro for Representative Merchant.
There you go.
Yes.
Allows member of the Advisory Council on the Controlled Drug Prescription Health and Safety Program to remain a member of the council until their replacement has been appointed,
I
so
think
they
the-
can conduct business.
I think the genesis of this was they were having trouble getting replacements, and this
Yeah.
just allows them to continue doing business. I will support it. Any further discussion? Seeing none, all in favor?
Aye.
Any opposed? Any volunteers for taking it out?
I will.
Senator Carson.
Yeah, I know.
House Bill 391.
I move on to pass.
I'll second.
Seconded by Senator Gendro. I have for notes, the moves from semi-annual to annually and agreement versus memorandum of understanding. That's what I had for notes. It does not apply to a protected health data. So
Yeah, I think this
I think that's the key
concerned,
point.
right, a level of data that was not HIPAA protected, that anything truly sensitive requires a separate kind of agreement than what we're approving here, so.
Yes. Further discussion? Seeing none, all in favor?
Aye.
Any opposed? Passes 4-0. Senator Perkins Coker, would you like to take this
Sure,
one?
I was gonna volunteer.
I could read your mind. No, I couldn't. That'd be scary. Pretty scary.
Let's hope not.
It'd be scary to have that power with anyone.
I don't think that's a power I would want.
I don't want
to
it.
read, to read people's minds.
Okay, House Bill 409.
If I may, Mr. Chairman,
You may.
I don't want to make a motion on this, quite frankly. I had a couple of questions, because I reviewed all of these yesterday.
Yeah.
There's no testimony from OPLC and no testimony from the board. So I was kind of like, okay, if we can, I would feel more comfortable if we did have Ms. Courtney come back and just be able to give us some information.
My apologies that I did not address this while she was here. It
that's
slipped
okay.
through the cracks.
Yeah, I understand that, and, you know, I'm just surprised that there was nothing from the board. Not even a yay or a nay, or we're neutral. Usually they are really on top of things like this. And so I'm just a little concerned that maybe this is something that slipped by them. So if we can just hold off on this one and ask Director Courtney to come back
So
and perhaps bring some information from the board.
I
That
have no
would be helpful.
opposition to this. I mean, part of the reason I'm pushing the FNs is because I'm trying to
Yeah,
get
I
as
know.
many as I can through
Yeah.
finance before we get really deeply embedded with the budget. I have an idea that this one is of minimal impact enough that it very well might be waived from going to finance.
Okay.
So I don't have a problem to Philip about, and I forgot which one it was, and sorry about that, that's on,
It's
that's
okay.
on me.
No, like I said, I went through them all yesterday, and I just write on the bill jacket if I have questions
Yep,
or
good-
anything.
good idea.
So it just makes it a lot easier. Okay, I think we're done.
61.
What about 461?
461 is when, let me figure out which one that was again, 'cause that is
Where's
not,
my thing?
Can I speak to that one, Mr. Chairman?
you certainly may.
I think it is a very
Okay,
focused, so there's like 48,000 New Hampshire
Oh,
folks
that
that are
was-
on the retirement system. I think this is a very, very, very small group, maybe 4 to 6 people at the very most. I think it's targeted. And of course, putting my hat on as a selectman too, and knowing my district, I think this would cause a lot of hardship for various towns. And I definitely am opposed to it.
I would agree largely with the comments of Senator Gendro. I think we all know our municipalities are struggling to find people, they're struggling to pay people, and so I just don't want to support making it harder for them. I also think the penalties are very severe, having put together 4 municipal budgets, so I would definitely not support the bill as is.
Would you all consider, or what would you think about making this into a study committee? Because I think I understand the concern. I totally understand the concern. I certainly understand the testimony we received from the municipal association as well as to the detriment that this could have on the towns and the school districts.
I don't think it's an issue, Mr. Chairman.
Okay.
I really don't think it's an issue.
I had put a note about a study committee with a question mark.
Yeah, I did too, because there was a question about what does "and the like"
Yes.
I,
So
I get it,
Yes.
and
here's my other thought, and if you'll entertain it, is that we hold the bill in committee and perhaps do a little bit more investigating on it before we decide what to do with it.
I think I agree, Mr. Chair, I think, I mean, the allegation is that they're taking these full-time positions, they're making them part-time, and they're not paying into the system. And I've always believed that the issues with our retirement system really begins with the municipalities, because they create the contracts, they give the benefits. And so, you know, we've got to figure out a way to deal with this situation, other than just paying down the unaccrued liability.
Well, and we heard certainly testimony from Director Carlin that it could have an impact on the other municipalities if
Correct.
enough municipalities did choose to go in this route.
Right.
I mean, I would be concerned if there were an inordinate amount of people abusing it, but I think there's only like 4 to 6 people
Well,
in the entire
unfortunately,
state of New
yeah.
Hampshire.
Well, unfortunately, we don't know how many, and that was one of the things that the director
Right.
testified to, that he doesn't really have a grasp of it. And that's why I thought maybe a study committee was to just take a look and see what was there, because it's a serious allegation if it really is occurring a lot. And to me, it may warrant the legislature taking a look at it. So it's
No.
just a thought that I had. I'm comfortable with re-referring, we can do it as a committee, or I'm comfortable with turning it into a study committee.
My concern is all it takes is one case for it to become a poster child.
Yes.
And then whatever rumors, innuendo, everything else is going to surround that. So any future legislature that's dealing with that, they're gonna have to wade through all of that. So I would support, Mr. Chair, if we wanna turn this into a study, so we can get a good grasp on just exactly what is happening here. Is it something that's happening predominantly in large departments, or is it something that's happening in smaller departments? I don't know. And I understand Senator Gendro's position that municipalities are very cognizant about the retirement system because of the cost. Though I will say that we've gone to the apex. I think the apex was in 2018, and we're now on the downslide, where if we stop making a lot of major changes to it and pulling money out of it, we're gonna pay this off.
Right.
And it's gonna continue to go down, lower, 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 lower. And hopefully I won't be here when they pay it off, because then you get to make a decision about, do you wanna continue with a defined benefit plan versus a defined contribution plan? And that will be a huge discussion. But we can't move there until we pay off the unaccrued liability.
You don't want to run for 8 more terms?
No,
We need you.
no, I'll be
Well,
way too old.
Listen, I put my thoughts out. Where are you guys on it? Would you support a study committee? I think that I think there's been a compelling complaint made, and I think it would behoove the legislature to pay attention to it and respond to it and be responsive to it. If we find there's nothing there, then we find
you
there's nothing there.
I'm not okay with that. And I don't know, maybe it's because I'm just not okay with that. In fact, if I had to make a motion, it would be ITL.
Okay, well, we have a motion of ITL. Is there a second?
Second?
We have a second. So just,
We'll end up with 2-2.
We will.
And no recommendation. I don't think that's gonna work too well.
I don't want to bring that to a vote personally. I think I would, if we're going to have that motion, I guess I would ask that you wait until we have Senator Altshuler here so that we have a clear decision from the committee.
Okay.
Would that be acceptable?
Okay?
And I'm okay holding this if you want to wait until
Okay.
we have it. So
All
are
right.
you willing to withdraw your motion?
I will withdraw my motion, my emotion.
Your
My motion.
And I'll certainly recognize you for a motion when we have the 5 of us here, so that
Okay.
we
Yep.
don't have a 2-2 split.
Okay,
Okay.
thank
So
you.
that's good. How many did we do?
Quite a few. I don't think there's any more,
No.
unless somebody else has. I'm
Yes.
sorry?
Everything is coming. And I think we're probably gonna be getting.
457 is the only other one. We haven't talked about that.
No, it's already gone.
Oh, we did already, I'm
We
sorry.
did that one.
Oh, my apologies, I didn't
No.
read far enough to
That
the
was
right.
I
yesterday.
think we're probably gonna be getting 4 or 5 more from the House today if they pass them?
That's what we've been hearing, so.
Yeah.
Hopefully, and I saved two that I haven't heard yet, and my hope was if we only had four more, we could perhaps just do them in one more day. I'm not sure that we can, but we'll have to see what the subject matter is on them, so. I would plan on, well, next Wednesday, we have some scheduled already. We have 5 on next Wednesday, and then I have 2 remaining after that I haven't scheduled. I'll accept the motion to go out of exec.
So moved.
Second.
All in favor?
Aye.
Anything further the committee wants to discuss before I dismiss us? Then we are officially done. Thank you all. I appreciate your time.
We didn't, well, okay.